Angelo Fick joins us now. Angelo, very good evening to you, and thank you so much for speaking to us. Just looking at that last bit of the visuals, I think the Commission Chair himself chuckled at some point and said Lucky Montana was holding back no punches. Of course, he started off by slamming the Commission for having a predetermined outcome. Is this fair comment, or is it just open season now for anyone wishing to take aim at the Commission and its chair?
Well, I think there are two things that go on for me in these multiple accusations, of which Mr. Montana's are only the latest. It seems odd for people to suggest that there is a foregone conclusion when there has been no report from the Commission on its work and no findings have been made, that we're still in the phase of, or the Commission is still in the phase of investigating, and that we have had no report from the chair of the Commission about any kind of findings or conclusions reached. And so I think there is some preempting going on by people. And this might be because, and I think this is where the second point comes in, there is a misunderstanding of how judicial processes work, what counts as evidence in them, how evidence is led in them, how conclusions are reached, and when they are reached. So in any society, there are multiple ways of engaging to come to truths. And one of them is, of course, the way in which politics does its work, which is by rhetoric. It's convincing you. It is about an argument, and what counts as evidence in a political space or even in your family space is very different from what will count as evidence in a legal space. And this is where I think many people need to think very carefully before they assume that conclusions have been reached. There is very little evidence of the judicial kind that anybody inside the Commission has come to any kind of conclusion about any of the people involved in it.
And if there was any convincing to do, it seemed Mr. Montana was willing to do it, and he was going to flip any script that has a particular narrative. I mean, his testimony at some point spoke of non-compliance that is not necessarily corrupt, and he continued to talk about this interpretation that he's corrupt, but he then is accusing Popo Molefe of being corrupt. But then what do we understand about the problems at Prasa given all of this? Was it a matter of personality clashes or different interpretations of process and procedure?
So what we're hearing from Mr. Montana, what we've heard from Mr. Molefe, what we're hearing from various other people is their story of what happened. And these people may very well believe their version of the story, but in a judicial process, that version has to be borne out by the evidence trail. And that evidence trail will be compared to what people have said. And so this is not a process that is like many people's assumption of what the Truth and Reconciliation Commission was. This is not just a moment where you come and you tell your story and we are expected to believe you on the terms that you set out. This is a judicial process that is about establishing whether your story matches the facts. And here I think many people's idea that they will come to the Commission and tell their story for absolution or for heroism or to construct themselves in a different way from how they acted may clash very directly with the evidential record, which includes the paper trails of contracts. And we've seen witnesses come undone on the stand when confronted with their version of the story in oral testimony versus what the paperwork shows. And this has often been in quite spectacular terms. The accusations that are leveled against the Supreme Court of Appeals or against individual judges in the high courts, again, there is a judicial process, there is a frame of law that has to be observed, and that has to be followed. If one does not follow that process and then comes to an open judicial process and levels these accusations in public, the first question will be asked that as a citizen of a law-abiding or a state that is founded on the rule of law, why one didn't follow the earlier processes of going to the Judicial Services Commission with one's complaints. And those kinds of issues were raised by the chair during the processes, but not to the prejudice of the witness, but simply to alert the witness that these are questions that are going to have to be asked.
And we'll come back to that in just a moment, the attacks on the judicial system and, those who head it. But I want to go back to the issue of interpretations. The ANC chairperson, Mr. Ngoyi, appeared before the Commission earlier this week, and he also seemed to want to differentiate between cadre deployment and deployment, more so the understanding of whom has the power to remove a president. Was this appearance indicative of the importance of these semantics and ultimately parliamentary oversight and constitutionalism, the interface thereof?
So I think what we have long had in the Republic of South Africa is a conflation between party and state. And if we go back to 2006, 2008, before she joined the Hang SA, someone she was then just a political analyst and intellectual in the country, but Dr. Mampeli Rampeli pointed out in her book Laying Ghosts to Rest, that it was important to dismantle cadre deployment because it was enabling corruption, that it was not hiring the best, but it was actually hiring, or not even the best fit, but was hiring people for their loyalty to a party. We've had Constitutional Court judgments, which have since resulted in the need to change the electoral system, which have pointed out how political parties have control over the deployees in the legislatures because of the party list system, and that this put many times members of the legislatures in a quandary because they either had to abide by their oath of office to the Constitution and thereby defy the political parties, and then their dismissal from the political parties and therefore their removal from the legislature was therefore entirely legal, and that this somehow took aside and put aside the fact that people voted for them on particular kinds of issues in the manifestos. And here again, we have that conflation in Mr. Mantashe's description. And it was a very complex and very verbose description of what he meant. And I think that it is a moment for South Africans to consider whether or not, and there are other statements from other members of the African National Congress who aren't in the executive, that suggest that cadre deployment works for the party. But as anybody who has looked at corruption issues, service delivery, problems, non-delivery, maladministration, reckless and fruitless expenditure can see, cadre deployment has not just had the effect of giving the ANC ideological control over the leaders of governance. It's also, on the watch of cadre deployment, led to great corruption in all three tiers of the government.
So while South Africans are still distilling in what is happening at the Commission, whom to believe and why to believe them, another significant occurrence this week was that, of course, of former President Jacob Zuma saying to the Chief Justice that he won't submit an affidavit to what he called sanitize the gravity of the repressive manner in which the court has dealt with these issues. Where does this put the authority of the Commission, the Constitutional Court, and their perceived legitimacy, especially for laymen who are having to interpret all of this?
So in writing about what happens in the United States under Donald Trump, the political scholar Timothy Snyder warns everybody and says what you need to do is defend institutions, and defend institutions that operate by principles. And this means that if individuals, as is their choice in a democratic society, choose to defy the institutions and the rule of law, they must subject themselves, as Jacob Zuma suggests he will, to the consequence of that, choice to defy or to, refuse to cooperate. The courts are duty-bound in order to maintain the rule of law and respect for the rule of law, to implement the law impartially, regardless of people's previous or current status in relation to political parties or power blocks. And this is, I think, a test for all South Africans, whether they support the principle of judicial judgments that can be reviewed through judicial process, or whether once you've exhausted, because of course the Constitutional Court is the court of last appeal, and this is what was said to Jacob Zuma in the communication between the Constitutional Court and himself, asking for his input on what he assumed the penalty could be should he be found guilty. His defiance of that means that he now wants to take this beyond the legal process, and there is nothing in the Constitution that provides for it, and there shouldn't be. If we are to be a rule-bound society, whether Thandeka appears before a magistrate for theft of a loaf of bread, or whether somebody appears in the High Court on charges of massive corruption, they should face the same process regardless of where they are and what wealth they have.
Thanks a lot for that, Angelo. I really appreciate it. I actually was going to ask you about another thing, but we have run out of time. But really appreciate your time, Angelo Fick. He is Director of AUWAL Socio-economic Research Institute.